morning, everyone, and welcome to the Court of Appeals. I'm Chief Judge Donna Stroud, head of the panel today. To my right, we have Judge Chris Dillon. To my left, Judge Toby Hampson. And we have one case on the calendar for argument today. Looks like everyone is in place and ready to go. And did y'all already arrange the, do I need to pull this down? Okay. If you already arranged the rebuttal time?
Yes, Your Honor.
It's got that set, okay. All right, very good. Then we are ready to proceed.
May it please the Court, my name is Stuart Poisson of the New Hanover County Bar, and I'm here today on behalf of the appellant, Martin Sturdivant. When Mr. Sturdivant went to work on August 31, 2011 at Lanesboro Maximum Security Prison, he had no idea that the simple action of bending over to secure an inmate was going to change his life forever. He was 55 years old at the time. He loved his job. He'd always worked in physical manual labor jobs in rural Anson County, where he was from. But on that day, he suffered a back injury that within a matter of weeks would take him completely out of work. This set off 2 years of litigation where he fought for the ability to have surgery just so he could go back to work. At the end of that 2-year road, when he was 57 years old, the Industrial Commission found that he was physically incapable of work in any employment. After that time, Mr. Sturdivant, having won his case, tried to go have surgery. Surgery was no longer indicated. He tried to go back to work with the state in any kind of light-duty job they would give him. They rejected that. They fired him. He was 57 years old. He then goes out, he tries to find the kinds of jobs that he knows how to do, but he can't do those jobs anymore. He applies for Social Security disability. He's approved. He's 59 years old. The litigation that brings us here today is about whether or not Martin Sturdivant has suffered a total loss of wage earning capacity. At the time he returned to the Industrial Commission to argue his case, he was 64 years old. And this court needs to ask itself, based on the opinion and award that the full commission issued here, what changed in that period of time from 2013, when Martin Sturdivant was physically incapable of work in any employment, to when he was 64 years old and he returned to court all those years later. The Industrial Commission erred in 3 ways in this case. It erred as a matter of law because it failed to take any note of the finding that it had made in 2013 that Martin Sturdivant was physically incapable of work in any employment as of that time. It erred because it misunderstood the law and what it means to have a total loss of wage earning capacity. And finally, it erred because it relied on incompetent evidence to support the conclusions that it made in this case. With regard to this first error that the Industrial Commission committed, it's very evident from reading the Industrial Commission opinion and award that it felt that because Martin Sturdivant had the burden here, that he had to prove by a preponderance of the evidence that he had a total loss of wage earning capacity, that they could not in any way consider this prior finding that he had a physical inability to perform work in any employment in 2013.
But the statute does seem to expressly contemplate that there is a separate application for these extended benefits, and that there is a burden by preponderance of evidence on the employee to have to show that they qualify for extended benefits.
That is correct.
So why wouldn't that contemplate a new inquiry into earning capacity?
Well, Your Honor, I look at that as the law of the case. And so in 2013, the law of the case was that Martin Sturdivant was physically incapable of work in any employment. He does still have the burden when he comes into court in 2020. He does have to prove by preponderance of the evidence that he has a total loss of wage earning capacity. But the question is, how does he prove that in light of that 2013 finding of fact? The Industrial Commission could have said, we reject your evidence. We find that your physical condition has improved. We find that you're now physically incapable, or that you're physically capable of some work. But if you look at what the Industrial Commission found, they didn't do that. They found that his physical condition had remained the same. In fact, they found that these 10 of 10 flare-ups that he was having at the time of the 2013 proceedings were now happening once per week. And so it doesn't mean that Mr. Sturdivant doesn't have the burden here. He does. It means that his burden is to show that his physical condition has not improved since 2013. And when you read the findings of fact of the full commission, he certainly met that burden. It was a misapplication of the law for the Industrial Commission to believe that it had to wholesale ignore its prior finding that he was physically incapable of work in any capacity.
So how much weight is that prior finding afforded? Because it doesn't seem like you're articulating that it's sort of automatically binding on the commission, but you seem to indicate that it should be given some level of weight. Is it more that that's kind of a baseline that the commission can then start from to determine whether there's been a change in condition?
Yes, Your Honor. Baseline is a good word. I was going to say the starting point. So that is the starting point. As of 2013, he was physically incapable of work in any capacity. Now we're going to review the evidence that he's presented, and we're going to see what the status is now, what has changed since then. Has his physical condition gotten worse? Has his physical condition gotten better? Has his physical condition stayed the same?
Because I think the concern, I think we'll hear from your colleague for the state, is that if we place too much weight on the prior finding of total disability, or the conclusion, whatever you want to call it, of total disability, that it sort of renders this new statutory process for extended compensation meaningless, right? That if you qualified for TTD 500 weeks ago, you're automatically going to qualify based on that prior finding for the extended compensation. So I mean that's part of the sort of the broader concern, I think, that we'll hear from your colleague. Yes,
Your Honor, and we're certainly not arguing that that's the case. It's very clear that the legislature intended for the injured worker to have the burden when when he or she comes back into court. So that's not what we're arguing. What we're arguing is that in the very rare case, like Mr. Sturdivant's case, where the Industrial Commission finds as fact that he is physically incapable of work in any employment, that is a finding of fact that stands as of that date. And that is the baseline or the starting point from where the evidence must be evaluated on the second time around. This does not gut the statute. This does not in any way absolve Mr. Sturdivant from having to come into court and prove his case. If he fails to satisfy the Industrial Commission that his condition has stayed the same or gotten worse, then he's not going to be entitled to benefits. He still has the burden. The problem here is that Mr. Sturdivant has gone to court now for almost 5 years. And if the Industrial Commission and this court don't take into consideration that he went through those 2 years of litigation and he proved that fact to the satisfaction of the Industrial Commission at that point, it's just patently unfair and it's incongruous to say, injured worker, you proved that you were physically incapable of employment when you were 57 years old, and now here you are 64 years old before us again. Your condition hasn't gotten better. From our findings, it's gotten worse, and yet we're going to find that now you're physically capable of work. There has to be some kind of explanation there, and that's all that we're asking.
Well, can't you be considered disabled if you are capable of doing something, but there's no job for you?
Yes, Your Honor.
Okay, so is it possible there could be a job available now that he's 64, not when he's 57, and therefore you could come to a contrary conclusion about whether or not he's disabled at 64, not at 57, because now there's a job available for him?
If the Industrial Commission were to find that there was a job that he is now physically capable of performing, not some hypothetical job, but that there is a job out there in the general labor market, it would have to provide an explanation as to what's changed. And it may be that his physical condition has changed. It may be that now there are jobs that he is physically able to do that weren't available back in 2013. But there's absolutely no analysis there because the Industrial Commission specifically said, we're not going to consider anything about this 2013 opinion and award. And they found that as fact, and they concluded in 2 different conclusions of law that they weren't going to do that. And so that is an error of law, quite simply.
So what did the commission base it on? What their interpretation of this new statute? That's a different standard? They
did, Your Honor, and that gets me to my second error that the commission committed. on the issue of whether Mr. Sturdivant had a total loss of wage earning capacity, the Industrial Commission not only did not consider its prior finding, it also looked exclusively at his ability to work. And Your Honor touched on a point earlier that's important here. You can be physically incapable of work, you can be mentally incapable of work. Everyone would agree that if you are in that category, you have a total loss of wage earning capacity. However, there is going to be a subset of injured workers who are capable of some work, but they're limited because of their injury and because of other pre-existing factors like their age, their education, the amount of time they've been out of work, their work history, and they can't find anybody to hire them. If you were to go out on the street and ask someone what it means to have total incapacity to earn wages, they're going to say you can't earn wages. If you ask somebody what it means to have a total incapacity for work, they're going to say you can't work. Those are two different things. And earning wages is a two-way street. In order, you have to be able to work, to do some work, and you have to have an employer that is willing to pay you to do that work.
Okay, so if I get injured and I'm able to do something, but there's no job for me today, and the commission would find at that hearing that I'm totally disabled, right? Because, is that correct?
That is correct.
So what is my duty as that injured employee for the next 500 weeks? I mean, can the employer come back into court two years later and say he's no longer totally disabled because there's a job out there, he needs to continue, I still need to go out there and make reasonable efforts to go find a job? Is that do I have to keep doing that?
Well, Your Honor,
If I'm doing something, do I just have to prove it once and for one time, or does or can the employer come in? I guess the employer, it shifts to the employer to show that I'm no longer disabled during that 500 weeks. Is that correct?
Your Honor, they can and they do. They come into court, they file what's called a Form 33, they go to a hearing, and they say, we think this injured worker is no longer disabled. Now, in that scenario, for the first 500 weeks, the injured worker who's gone to court and proved his case has a presumption. But if the injured worker has not gone to court and proved his case, when the employer files for that hearing, that injured worker has to come forward with some evidence.
So I'm just trying to understand, total loss of wage earning capacity, is that the same thing as what I have to prove in the initial disability? That initial disability, I just got to prove on that day that there's no job available for me that day because I'm totally disabled. That I use reasonable efforts, I can't do it that day. So are you saying it's the same thing after 500 weeks? Because I would think that, I think that's what we're grappling with. Is it the same thing, or is it just, or does all that have to be shown is that I should be able to get a job at some point? You just have some expert saying, yeah, he can get a job. Might not be all right. It might take me time to get a job, but I can get one. I think is that where the crux is, or where the difference is of opinion, what this means?
Well, Your Honor, I think that gets to the heart of it. And our position is that disability and total loss of wage earning capacity are separate inquiries. We're not saying that it's the same standard. Disability is defined in the Act, and it is tied to the same or similar wages. So when you're going in proving disability, you're showing I can't earn the same or similar wages right now because of my injury.
Total disability means I can't earn anything.
It means you totally cannot earn anything.
Partial disability means I can earn something, but just not what I used to.
But not what I was earning. When you get into this section that we're dealing with, total loss of wage earning capacity.
Which is different than total disability, is what you're saying.
I am. There is no tether to the same or similar wages that you were earning in your prior employment. Disability is tethered to the same or similar wages. And so here, the methods of proving it are the same. You come forward with evidence that you're physically or mentally incapable of work. You come forward with evidence that you're capable of some work, but you've done a job search and it's reasonable and you haven't been able to find anybody to hire you. Or the third option is that you satisfy the court or the commission that you're capable of some work, but because of your age, your education, and your work history or other factors, it would be futile for you to look for work.
How's that different than total disability? Isn't that the same way? Isn't that the way you prove total disability is you can't do work, you can do work, but there's nothing for you, or be futile for you to look? How's that different?
Total disability is different because it's tethered to the same or similar wages. So for instance, if the employer came forward with a job that paid less than half of what you were earning previously, you would not be required to take that job, and you could still prove you're totally disabled. Under this scenario, for total loss of wage earning capacity, if you can get somebody to hire you for a job that pays half of what you were earning before, you don't satisfy the standard.
So if I'm disabled, if I'm injured at work, but I can go get a job making less than half of what I was making before, that's not partial disability, that can still be total disability?
It can be partial disability if the injured worker elects to take that job, but the injured worker is not required to take that job under the first 500 weeks. It would not be considered suitable
Is that
employment.
based on our case law?
Well, suitable employment is based on case law, and then that definition was codified with these 2011 changes. And so it is in the definition section of the Act.
Did the codification change how we applied suitable employment? 'Cause as I read it, all it says is that after reaching maximum medical improvement, is employment that the employee is capable of performing, which could be anything. If I'm capable of doing a job that makes less than half, why isn't that suitable employment? How would it ever be total disability if there's a job I'm able to do under this definition, not based on our case law prior to 2011, but based on this definition? If I'm capable of doing something and I can get a job doing it, how am I ever told I can elect not to take that job?
The job would have to be suitable, and there are reasons that the jobs aren't suitable. For instance, an employer of injury could offer you a job that they made up for you, trying to show that you have some earning capacity. You could go out in the general labor market and try to find a job, and you could find a job that pays you on commission, and it's not reliable. And so the Industrial Commission finds that that's not indicative of earning capacity.
Well, I'm just reading this definition of 20, it says, after reaching maximum medical, is employment that the employee is capable of performing, considering the employee's pre-existing injury-related physical and mental limitations, and is located within 50 miles. Yeah, and I don't see any limitations. So if I could be a greeter at Walmart and make $10 an hour, or $15 an hour, whatever people make there, is that per se suitable employment if I'm able to do it? Or could I say that I don't want to do it, or the commission, could the commission find that's not suitable employment, even though I have the physical and mental, based on my physical, I could do the job?
If the Industrial Commission was basing it exclusively on the wage issue, based on that codification, they would likely find that it was suitable. However, when you're looking at the job, you have to look at the totality of the job. You're not just looking at the wage. And the reason that that statute was enacted in 2011 was to make sure that these are real jobs, that they are real jobs available in the labor market, and that they're not some kind of hypothetical, made-up or fabricated job.
You said that you said under suitable employment, there could be a real job where I would earn less than half of what I was making, and that could be construed as not suitable employment.
It could be, Your Honor.
Based on what in the statute, if it's within 50 miles? Why under the definition of the statute, or do we have a case since 2011 that interprets this? Because I'm wondering if this changed it, because I thought the whole purpose of the 2011 statute was we want people to go back to work, no matter what it is. And so maybe the courts were too loose in what they allowed the commission to interpret as suitable employment. And so did they limit it by just saying, if I'm able to do it, it's within 50 miles, then that's suitable employment?
The major change with regard to that particular definition is the pre-maximum medical improvement portion that doesn't apply here.
Is this a new definition in 22? Was it ever in a statute before?
It was never in a statute before. It was in case law.
It was in case law. So does this statute match the case law? Or?
Previously, the case law looked to some extent at benefits and wages as well as these other factors, but the whole codification of suitable employment divided it into two sectors. One is pre-maximum medical improvement, one is post-maximum medical improvement. This thing with the 50-mile radius was added in as a part of that negotiation, and then the biggest portion that was added in was that pre-maximum medical improvement suitable employment can be anything with the employer of injury. So it can be a completely made-up job, and the employee can be made to do it if the doctor signs off on it. But that's not what we're dealing with in this.
I was going to say, getting back to the extended benefits statute, when we talk about total loss of wage earning capacity, it doesn't really seem that whether employment is or is not, quote, suitable under the statute is particularly applicable to that analysis. I mean, it almost sounds like you could have a make-work situation if the state had offered, and I'll ask you to respond to that, if the state, had created a make-work position and said, here's some, we'll pay you $7.25 for 1 hour, 1 week, and that's some wage earning capacity. How would that have fit under the statute?
Your Honor, we have very definitive case law that make work like that is not available in the general labor market is not indicative of wage earning capacity. And that really, I contend that the suitable employment definition that Judge Dillon was talking about that ensures that this is a real job within the relevant labor market, that does apply to these cases. These injured workers who are coming in at week 425 and beyond, they're necessarily going to be at maximum medical improvement. It's been 10 years since they got hurt. So we're not even looking at that first part of the statute that says it doesn't have to be a real job.
Why didn't they use that language? They use it in D. They say in D, you're totally disabled unless the employer can show that a prime shows the employee is capable of returning to suitable employment. Why wouldn't C say the employee can show that he's not able to return to suitable employment? They use this other phrase.
And, Your Honor, I think that's
They mean different things.
I think they do, Your Honor. Looking at this language that the legislature used here, if you look at B, I've highlighted and underlined, they use total loss of wage earning capacity. If you look at subsection D, which applies to permanent disability, permanent total disability, they use this language, return to work in any capacity. And so if they meant the standard for C to be, this injured worker is unable to return to work in any capacity, they certainly could have said it because they said it in D. But here they said total loss of wage earning capacity. And what's important in that definition is earn. It means to obtain money in return for labor or services. And so if no one will pay you to perform the work that you are capable of performing, you have no ability to earn. You have a total loss of wage earning capacity. And the way that the law changed in 2011 with this legislation is that people like Martin Sturdivant, who were awarded disability benefits, who proved their case over 2 years of litigation, who were fired from the state, who were not offered suitable employment, who looked for work on their own, who were evaluated by a vocational counselor and recommended for vocational services, which the state refused to provide, those people generally were going to receive benefits for the rest of their life with no further review from the Industrial Commission or anyone else. This statute changed that. Now, Martin Sturdivant is here again at week 425 before this court. He doesn't get a presumption of any kind of disability whatsoever. He has to prove his case from whole cloth all over again. And so there were a lot of changes. If he wins his case, he's now retirement age. Because of these changes in the statute, the state is going to get an over $1,000 credit per month against the benefit that he's awarded.
Okay, let me ask you, okay, disability, I have to prove that today I can't get a job. Total loss of wage earning capacity, do I have to prove that I can never get a job either now or in the future? Or do I just have to prove again, right now I can't get a job?
Your Honor, there's a case called Dale versus Kellex that says that the Industrial Commission or the court cannot look at future disability. It's DAIL. And so you can't look at what somebody's condition is going to be in the future. You're judging it at this point in time. And the statute leaves it open for the employer to come back and to challenge it if the injured worker proves total loss of wage earning capacity. So what Mr. Sturdivant has to prove here today is that at this point, he either is physically or mentally incapable of any work, or that he's capable of some work, but that there isn't anybody that's going to hire him for that work. And the way that he proves that is either by doing an unsuccessful but reasonable job search, or he gets a vocational rehabilitation expert to come in, do a vocational assessment, and indicate what the opinion is. And here, Ms. Johnson indicated that an employer's not going to hire him. This gets me to my final argument. I know I'm almost at 6 minutes. I'll take one more minute. The Industrial Commission relied on incompetent evidence here. They found that Mr. Sturdivant could perform part-time sedentary work at least, and yet there's no evidence of any part-time sedentary jobs in this record whatsoever. Melissa Hale testified that she only looked at full-time jobs. Her labor market only has full-time jobs. There is no evidence of the availability of any kind of part-time sedentary employment. And the Industrial Commission.
But is it his burden to prove there's a lack of that job? It's his burden. Is it his burden to prove there's a lack of temporary jobs rather than the employer's burden to show that there are temporary jobs?
Well, the Industrial Commission, Your Honor, it is his burden, but I don't believe it's his burden to show that. His burden was to show that his physical condition had not improved. The Industrial Commission found that. His burden was to show that he's not able to find anybody who's going to hire him. And so he looked for jobs. He also proved, and the Industrial Commission found, that at least once per week he's going to have to miss work because he has 10 of 10 pain. And the evidence is that those periods are going to last for 1 to 2 days at a time. There's not an employer in the world that is going to hire somebody, full-time or part-time, if they're going to have to miss work on average once per week. And that's the part of the equation that the Industrial Commission missed. I'm going to save the remainder of my time for rebuttal. I thank the court for its questions today.
Thank you.
May it please the court. I'm J.D. Prather of the, I'm Assistant Attorney General with the North Carolina Department of Justice. I'm here this morning representing the self-insured employer in this workers' compensation claim. It's the state, it's the North Carolina Department of Public Safety. It's a pleasure to be here. We're going to argue that the full commission correctly decided this case involving extended compensation. As you know, this is an issue of first impression, sorry. It's not the first time the issue has been before you, however, because about 2 weeks ago you did hear the Dept versus Human Resources case. But there is a novel issue in this case, and that is the presumption that plaintiff contends applies in this extended compensation context with regard to Watkins versus Central Motor Lines. And I'm going to talk about that one first. But before I do that even, let me just say that there are some big picture issues here. Those involve interpretation of the new statute enacted in 2011, that's 9729C, which is extended compensation. There are some case-specific issues, that's the competency of the evidence. I'm not going to address those unless there are specific questions because I don't think that's why we're here this morning. So let's get right into the issues regarding 9729C. Before I even get started, I want to make sure that you know that I'm going to get to the most crucial issue, which is the distinction between disability and total loss of wage earning capacity, because that is crucial, but I'm not going to start there, so I just want you to know I'm going to get there. But when we look at 9729C, first of all, let's start with Watkins. That presumption does not apply in this case. The Industrial Commission rejected the argument that it applies in extended compensation cases, just like it rejected the arguments that res judicata or claim exclusion theory does not apply and that collateral estoppel theory does not apply, that is issue preclusion. And
So is it the state's position that we are just beginning brand new? It's a clean slate. The employees got the same burden they had in the first place, back, before the deputy the first time they tried this case to establish disability, whether or not the state's admitted disability or not.
Right, there is a prior ruling in this case, and that's why this one is first impression on the issue of Watkins, and it would have been on res judicata and collateral estoppel, because there is a prior ruling in this case from 2013 when the parties entered into a consent order. But I would say that 2013 ruling is the law of the case. It's just that it involves different questions. In 2013, the issue that was raised was whether Mr. Sturdivant was disabled at that time and entitled to disability compensation under what's now 9729B. Coming forward to 2020, 21, pardon me. The issue is whether he's proven by a preponderance of the evidence that there's been a total loss of wage earning capacity. It's a different standard, and that's the reason that the Industrial Commission rejected the arguments that it was compelled to award extended compensation by virtue of res judicata or collateral estoppel, because they're different standards. It's not the same cause of action. They're not identical issues. The res judicata and collateral estoppel issues weren't raised on this appeal. It's just the Watkins presumption, which wouldn't have compelled a finding of entitlement, but it would have created a presumption. In other words, shifted the burden of proof back to the defendant when the statute 9729 specifically puts that burden of proof with the plaintiff.
So is it the state's position that sort of the four Russell factors really have no application to this analysis?
That gets to the heart of how to interpret the new standard, total loss of wage earning capacity. I've heard argument this morning that, as I understood the argument, was that there's a concession that disability is not the same as total loss of wage earning capacity. But as I read the brief, I understood there to be a common inquiry between the two standards, which I interpreted to mean that basically disability is the same as total loss of wage earning capacity, and I'm going to explain to you why that would not be the case.
Well, as I understood it, and your colleagues can address this on rebuttal if I misunderstood it, but my understanding was that the distinction, if any, was the question of whether of actual wages, of whether that the wages the employer or employee could earn, were sort of relative to what they could have earned before. That's sort of more going to disability, where I think there is a concession that where it says loss of total wage earning capacity, it means total wage earning capacity.
Yeah. And Judge, you've hit on the key element that I'm going to have to jump forward to really respond to that question, and that is the difference between disability and total loss of wage earning capacity. So I want to give a little bit of a history if I can, and if you will bear with me, I'll do it just very quickly. Looking backward in time, the evolution of the term disability starts in 1929 when the Workers' Comp Act is enacted. For disability, there was a limit of 400 weeks. 1929, fast forward to 1973, the legislature removed that 400-week limit. So now, but it was not without restraint. So now there's no 400-week limit. But the limits were still restrained by the fact that employees whose injuries were subsumed under the permanent partial disability statute of 9731 were limited to that and could not continue to receive 9729 disability benefits. So the PPD was the exclusive remedy in lieu of all other compensation. That's the language of 9731. So there was still a limit. Then move forward to 1986. The Supreme Court came down with the ruling in Whitley versus Columbia Lumber. And in that case, the Supreme Court says to the employee, you may elect the more favorable remedy between permanent partial disability under 9731 or ongoing disability under 9729. So in effect, what the court said was that there is no effective limit on the amount of TTD, or temporary total disability, that the employee may receive. So that's where we've been since 1986. There's been a lot of case law since 1986 that has imbued the term disability with meaning that gets away from capacity to earn wages, which is where it all started. And I'm going to argue to you that it's very important that this court take note of the distinction between the language in 9729B, which is disability, where they actually use that term twice, and 9729C, which they just enacted, which did not use that one-word term disability, but instead went with 6 words, total loss of wage earning capacity. So why is that? The plaintiff's contention is that when you interpret total loss of wage earning capacity, it should be interpreted not by those words, but rather incapacity to be hired to earn wages. If you look at their brief, I think it's Roman numerals 1B argument, and that there's a common inquiry, or just pardon me, strike that, but basically that's how you should interpret it, to add the words to be hired, instead of just focusing on the plain meaning of the language of the statute, which is capacity to earn wages. So I'm going to now
earn wages if I can't be hired.
Well, capacity. I mean, so this gets back a little bit. So I'm going to go back to another argument, which is how is the statute to be interpreted? And if our brief sort of sets out the statutory construction rules about if the language of the statute is unambiguous, then this court has the duty to give effective plain meaning of the words of the statute. So total incapacity to earn wages, what the commission did here was to say that means an inability, equating capacity with ability to earn wages in any employment, which is the same as total or any employment. So the commission did give the plain effect to the plain meaning of the unambiguous language of the statute. But your question is good.
Would education be a factor in determining wage capacity?
Yes, Your Honor, that's a good question. So what that goes to is a vocational ability to do work, to earn wages. I think that's a relevant consideration under the extended compensation statute. What we're contending is not a relevant consideration is what the Russell versus Lowe's case articulated as the burden, as the way that disability may be proven. So at page 20 of our brief, if you want to refer to that, it gives what Russell tells us. And so basically, I'll just run through that. Disability could be proven by proof that the employee is incapable of earning wages in any employment, that's one. Or two, evidence that he is capable of some work, but that he has, after a reasonable effort on his part, been unsuccessful in his effort to obtain employment. So now we're talking about the capacity to be hired, an unsuccessful job search. We're talking about not the capacity to earn wages, we're talking about a question of hireability. So vocational considerations like what you're referring to, Judge Hampson, is education, work training, those kinds of factors. Those are vocational factors that can be considered. But an employee's going out into the workforce, even though they are capable of working, but not being able to find work after a reasonable job search, those are disability considerations, and that's why disability has imbued with all these meanings that go away from capacity to earn wages and go to, motivations, incentives.
But isn't the concept of requiring an employee to undertake a reasonable job search actually more of a protection for an employer, to prevent an employee from simply coming into the commission and saying, well, can't work?
Well, I understand that, what you're saying, but the legislature didn't use the term disability when it enacted 9729C. So there is a reason for doing so, and that's where you get into legislative intent. Even if you don't agree with the proposition that the statutory language is unambiguous, and if you go to the intent of the legislature, you look at what it was enacted for. And it was enacted to incentivize employees to return to work. That can be done with carrots, with sticks. In this case, the enactment actually did both. 9729C made a cutoff for total disability compensation and forced the employee to prove an entitlement to extended compensation with this new standard. At the same time, it gave a carrot. It enacted 9732.2, which is a vocational rehabilitation benefit that's available to employees whenever they have not returned to work or have not returned to work at least 75% of their pre-injury wages. So there are incentives, and then there are motivations on the other side, which are here's a cutoff, and you're going to have to work harder to get back to work. This was the motivation. And if you look at the words of the Senate Pro Tem leader at the time, back in 2011, Pro Tem leader Falwell, he said, we have to get North Carolina back to work so that the Workers' Comp Act doesn't become a retirement system, or does not continue to be a retirement system. Because what happened was, when the issue is just have they not been hired after a reasonable job search, under Whitley, they were just entitled to benefits for the remainder of their life. And in effect, they just received those benefits for their lifetime. So why did the legislature use different terminology in 9729? It's that motivation. It's to cut off. It's to force the employee to prove by a preponderance of the evidence that there's been a total loss of wage earning capacity. Not that, looking at Russell's second method of proof, if you read the actual language of that case, it says the production of evidence that he is capable of some work, but has not found that work after a reasonable job search. Capable of some work, isn't that entirely inconsistent with total loss of wage earning capacity? Russell does not apply anymore. That's why disability was not used in 9729C as it was in B, if that makes sense. If we were to adopt plaintiff's argument that you should add the words "to be hired" to the language, and those words are not shown, they do not appear in the statute. If we were to add those words, we would have a Russell versus Lowe's standard for proving disability, which would
Necessarily, because, I think total disability means that I've got to show, if I'm the injured employee, that I cannot be hired now. That I've gone out there now, and today I can't find a job. But is it possible to interpret total, that if I have to show, I do have a burden of showing, but I have to show that I can't be hired now or ever. I may have some ability to work, but I can bring in evidence somehow that nobody would ever hire me now or ever because I've got, ever. I may be having trouble today, but I've got to be hireable at some point in the future. Is that possible? Is that how we get that hireability part in it? But it just raises the burden on me. And for disability, I just got to prove it's today. I can't be hired. But for this Section C benefit, I've got to show not only can I not be hireable today, but ever. Even though I might have some ability to do something, but because of I don't know how I prove it, but maybe there's a way that I can show that I'm just not, that the problems I have today to get the job will never go away.
The second prong of Russell, which allows an employee to prove disability by showing that there's been an unsuccessful job search, even though they are capable of doing work, it creates a problem in terms of motivations. And so if hypothetically an employer had 5 applicants and they could only hire 1 person for the position, they're going to make their decision. All these employees are capable and qualified to do the work, so they have that capacity to earn wages in that job. But because of a number of different factors, the employer is going to make that decision, and it usually comes down to motivation. It could be that there's, the employee does have limitations that they can't overcome without help, and that's why the vocational rehabilitation statute hasn't been enacted to assist employees in that regard. But taking the hireability aspect out of proving, total loss of wage earning capacity where it was relevant for disability takes all incentives and motivations out of the process. It's just a bright line standard that raises the bar for what needs to be proven. It cannot be the same as what it was for disability. Otherwise, the enactment, the Reform Act, would have no practical impact. Right.
Well, isn't what I'm saying raise it? I not only have to prove that I'm not hireable today, but I have to prove that I'm not hireable ever.
You mean to prove disability?
No, to prove under disability, I just have to prove that I'm not hireable today. I have some skills, but no one's going to hire me today. I'm totally disabled until the employer can come in 100 weeks from now and show that I am hireable or whatever. But under C, I'm not, you're saying that I see a way I could read this without, and give it a higher standard to me and still have the hireability component in there. But the hireability is not so much that I'm not hireable today, but I've got to prove as the employee to get under C. Under B, I just have to show I'm not hireable today. But under C, would it be a different standard to say that I got to still show there's hireability component, but I've got the burden as an employee to show that this will never change. That this, I don't know how I prove that, but that would be a burden. If I have some skills to do something, I've got to show that no one would ever hire me now or in the future.
Well, I understand that may be a reasonable view of it, but I will point out that in terms of total disability that's always had, written into 9729, there's also been a permanent and total disability entitlement as well, where they actually attach the word permanent to the total disability. So, in other words, there was a permanency element as well. There is no permanency element written into 9729C, so there's no case law, there's nothing in the statute itself, that clearly requires that the employee come forward with evidence that this total loss of wage earning capacity also be a permanent one.
Well, under the statute, too, it can be reviewed later, too.
That's correct,
The
yes.
employer could say, hey, they could file a motion and say, I think that now things have changed, and they could
That's
come
correct,
back.
yes.
Right.
It does have a procedural mechanism for coming back and reviewing the award in the event that changes on the employer's behalf. So just to sort of give you the framework of my argument is, first of all, the legislature used a different terminology in 9729C. So there's I think it's a clear presumption that there are different standards. There's case law out there that tells us and there's been a reform to a statute, the legislature either intends to give a new right or to take one away that had previously existed. I don't think it can be argued that in terms of the 9729C extended compensation statute, the legislature was giving a new right. I mean, there's just no way to interpret it that way. So it was taking away a right. And the reason for it was because this was the stick part of the whole motivation part of it. This was an incentive to return to work, which creates a bit of a hardship on the employee. Now, the employee has to actually really go back to work if they have wage earning capacity. So this gets us back to where it all started back in 1970-29.
So articulate the standard for me, because I hear you sort of rejecting the Russell standard. I hear you sort of rejecting the standard of, well, proving future incapacity. So articulate a standard for me that would apply for an employee to show an entitlement to these extended benefits. How would you articulate the test, the standard that a commission can apply?
Well, I think that I could do it, but I think it's better just to rely on what the full commission did in this particular case, because I agree with it entirely. So how it interpreted 9729C's language, the commission said, quote, a plaintiff must show that they have a total loss of the ability to earn wages in any employment. So I see that having two separate components that are completely consistent with the plain language, unambiguous language of the statute, which is total loss of ability, which we've cited the definition for capacity, ability to earn wages in any employment, bringing us back to the total loss. So in other words, that's how the full commission interpreted it.
So does that concept of ability to earn wages, taking that component of it, does that include an individualized inquiry into this employee and what this employee has the ability to do, considering all the factors?
In part. So this is where it gets a little fine-tuned, but vocational considerations, education, training, pre-existing health conditions, those are completely relevant and appropriate inquiries. On the other hand, hireability considerations, the reasonableness of the job search, anything that goes beyond just a straight capacity to earn wages is outside of this new statute. And for the reasons I've explained, because if you were to include those additional considerations, those Russell considerations, in addition to the straight vocational considerations that you're referring to, what we have is a system that's no different than it was before the reform in 2011. We would go back to a Whitley standard of disability being available to any employee after 500 weeks. The reform would have no meaning.
So it sounds like you're advocating more of a theoretical analysis of whether there could be, irrespective of what the actual job market is in the community, irrespective of these other considerations, that if there was any job out there, whether it's, if the employee lives in Asheville and the only job out there is on a fishing boat.
I'm going to offer my own opinion on that, although I think we're going to have, I think that the 50-mile radius, I think that's a vocational consideration and fair game to address that. I think so long as, there are some jobs that have a strict age requirement, but there's age discrimination also. Age aside, education, work training, mental aptitude, those are vocational considerations that were addressed in this case and that I think are appropriately addressed when we're talking about wage earning capacity. But when it comes to whether an employer is willing to hire this employee, this individual employee, that's where we're talking about the motivations that have been a problem for the Workers' Comp Act since 1986. And that's the Russell considerations of when there's the ability to do some work, but there's been an unsuccessful job search. Those are no longer fair game because that doesn't go to capacity or ability. That goes to hireability. And hireability is always subject to an employee's motivations and how they're putting themselves out there. If that makes sense. I don't know how much time.
The motivation's an issue because if I'm making $100,000 a year and I'm disabled, under C, I'm entitled to $66,000 a year for the rest of my life if I'm totally disabled.
Tax-free.
But if I'm able to make $5,000 a year doing something, if I have a little bit of ability, that actually cuts my pay way down. I make $5,000 because I'm not entitled to this 70C benefit anymore. If I'm 500 weeks into it, I get nothing if I'm able to make $5,000 a year.
The Workers' Comp Act had become, in effect, a retirement system because of Whitley not having any limits on how long total disability would continue. And I think that that's what the Senate, actually bipartisan legislation in 2011 was addressing, is that this is no longer a retirement system. There is a 500-week limit. There's a safety net for those who have true total loss of wage earning capacity, but there are also additional benefits to help them get back to that point in terms of vocational rehabilitation.
So you're saying C is a safety net for people that can't make any money after 500 weeks?
Right, without regard to how hard they tried to find a job. I mean, that's such a subjective determination that the commission has faced.
It doesn't provide me a safety. If I'm able to make $5,000 a year, it doesn't provide me much of a safety net, because now there's no safety net for me. If I make zero, then I'm going to get my $66,000 every year and I can live. If I make 5,000, there's no safety net for me.
Well, at $5,000 a year, then the employee would have been eligible to receive vocational rehabilitation assistance under 9732.2 because it's less than 75% of the pre-injury wages. And that entitlement to vocational rehabilitation not only includes vocational assistance from an expert, but also would include education as set forth in 9732.2, which includes I think community college and things like that the employer pays for. So.
So was there ever any attempt for Mr. Sturdivant to have any vocational rehab or any assistance?
Not that I'm aware of, and I haven't read that part. I haven't seen anything in the record that would tell me that there was.
I mean, as I recall, and I don't believe there was any of that.
And I was not the attorney who
Right.
tried the case originally, so I don't
Is
remember.
that his burden to seek it?
Yeah, it says that the employee may receive,
You've got to ask for it.
and it tells when it's reasonably likely it's going to assist. So yes, I think he has to ask for it, yes.
Well, what about I want to ask you just to address the fact about there not being any evidence of any any part-time positions. I mean, the commission found that he would have pain, let's say once a week or on a regular basis, that he wouldn't be able to work full-time. But
Well, the commission's finding of fact was at a minimum, this is his ability. So it did not say that this was the upper limit of what he can do. There was a lot of play in terms of his restrictions. The doctors went from no restrictions at all to, I think it's sedentary, to sedentary to light. The commission ultimately went with the employee's self-described limitations, which would place him in a sedentary position. The argument was understood. The commission acknowledged that he was saying, I have bad days. So they said, at a minimum, he can do part-time work. That's not to say that he couldn't do full-time work, and I don't think there's any evidence that he absolutely could not. That was just acknowledged by the commission that was a raised concern.
so if the commission, because let's say found that he would have, say, one bad day out of 10 or once a week or whatever. So what if it was the other way around? If he had like 9 really bad days and then that one day he would have a great day. He could do great stuff on that one day. Would that mean that he is then considered able, he would have wage earning capacity because he could work on that one day?
Well, and this is where we're getting into, I can't give you my opinion because I think it really requires us to look inside the record to the vocational experts. And in finding of fact 36, the commission accepted Melissa Hale over Ashley Johnson. And she testified that I believe there's work out there he can do when you also consider Mecklenburg County, which Ashley Johnson didn't. So they accepted her testimony over Ashley Johnson's. And so as the finding of fact, I think, is binding, and it's also supported by the evidence of the record. So I think that is, going back to Judge Hampson's question, though, I think that's a reasonable area of inquiry by the commission under the new standard. But just to sort of bring it all back together, there aren't common inquiries when we're looking at disability and we're looking at total loss of wage earning capacity because the legislature didn't use the same terms. There's a reason for it. It gets away from capacity when you start bringing in disability with all the layers of understanding that have been imbued in that term. So So in summary, I think that the Industrial Commission interpreted this new law correctly by giving plain meaning, the effective plain meaning of the words used. They're unambiguous. It also found that this is not a disability standard, which rejected the whole argument that the Russell methods of proof don't apply. And finally, if appellant's argument that the Russell methods of proof, hireability, becomes relevant, we would be back to where we were pre-2011 amendment, because disability and total loss of wage earning capacity would in effect be the same thing, and all of the intended impacts of changing the motivations and incentives would be removed. So I'd be glad to answer any questions. I'm getting a bit hoarse. So thank you.
All right, thank you. Rebuttal?
Thank you. May it please the court. I'd like to answer the question on what the standard is. And the standard is either you can't work or you can do some work and you can't get anybody to pay you to do that work. That is the standard. And as Judge Dillon indicated, during the first 500 weeks, if you can do $5,000 worth of work, you're not required to take that job. And that goes to the questions you were asking earlier, sir. It's not just the definition of suitable employment, it's the definition of disability. Disability means incapacity because of injury to earn the wages which the employee was receiving at the time of injury in the same or any other employment. So pre-500 weeks, if they find you a $5,000 job, you are not required to take that. Post-500 weeks, if you can do a $5,000 job, you don't get the benefit.
I thought that was the definition of partial disability, that I am able to earn not quite as much as I was making. I'm not totally disabled if I can do something and make less than the $100,000 a year, I'm just partially disabled. Is that not right?
That's not the way it's applied right now, Your Honor. The way it's applied during the 500 weeks is that the injured worker could voluntarily go take a part-time job, but the injured worker cannot necessarily be required to under this definition of disability. And they're different strata here. I mean, we're talking about you were earning $20 an hour, now you're earning $18 an hour, or we're talking about you're earning $20 an hour and now you're getting paid.
But 9730 says partial incapacity means I get compensation equal to the difference between my average weekly wage before the injury and the average weekly wage which I am able to earn. Not that I accept, but if I'm able to earn something, aren't I just partially disabled?
Well, Your Honor, that is looking at the differential in the wages, but what we're talking about here is the $5,000 versus the $66,000. And during the first 500 weeks, you're not required to take that job. And that's a combination of the definition of disability and a combination of the suitable employment standard. With regard to the second 500 weeks that we're talking about, if the injured worker can do that $5,000 job and can get hired to do that job, then he doesn't qualify. And I want to make sure that the court understands that. To answer Chief Judge Stroud's question, there was vocational evaluation in this case in 2016. The state hired somebody to do that, and that was rejected. The state rejected that person's recommendations to provide the services. Those services were to help Mr. Sturdivant learn how to interview, to learn how to prepare a resume, and learn how to look for jobs that weren't the jobs he used to do in the past. And the state refused to provide that assistance. The Russell versus Lowe's factors absolutely still apply here. And as Judge Dillon indicated, there's a lot of motivation that's built into this statute. And the concept that an injured worker can't come into court and show that no one will hire him either through an unsuccessful job search or through a vocational expert who has indicated that it would be futile for him to look for work simply doesn't make any sense. We're looking at loss of wage earning capacity. And it's the same thing. Loss of wage earning capacity here is a total loss of wage earning capacity. Previously, it's loss of the capacity to earn the same or similar wages. The methods of proving it are the same. The standard is different. We don't believe that the court needs to get to that question. We believe that the court should reverse and direct the Industrial Commission to enter an opinion and award consistent with its detailed findings that Mr. Sturdivant remains physically incapable of work in any capacity. But if the court reaches these other issues, we ask that the court reverse and remand and direct the Industrial Commission to correctly apply the law and redetermine the facts. Thank you very much.
Thank you very much. Thanks for your arguments. And
Good job, JD. I mean, we'll see what
It's a tough one,
happens.
isn't
It is a tough one. It's a tough one. I'm like, but they can't make him take that job.
I know, I mean, it's hard to wrap your head around it as a workers' comp practitioner.
I know, I know.
So then I'm thinking 3 judges, so I'm sort of like,
Well,
from the bottom up.
And you know how we are. We love